Hi guys, I'm back. We do have another motion for continued sealing. This one is now filed by Betty Buzz, which is obviously Blake Lively's LLC. That they are the company where she produces her beverages, basically. So let's have a look at this. Again, these are short motions, so I'm just going to do several individual videos on each filing that comes down just to keep them all separate. Okay, dear Judge Lyman, in accordance with the parties' agreement so ordered by Your Honour, we write on behalf of non-party Betty B. Holdings to move for continued sealing of certain documents attached to the parties' summary judgment papers, specifically Betty B's second amended and restated limited liability company agreement and Betty B's sensitive competitive business information contained in A, 2 highly confidential board updates, and B, 2 years of K1s. C, 2 pages from the deposition transcript of Betty B's 30B6 witness, and D, certain portions of Miss Lively's expert reports. We attempted to confer with both parties about our request. So they attempted to confer with both Wayfarer and Blake Lively. Miss Lively does not contest our proposed sealing request. Well, of course she doesn't. Of course she doesn't. She is Betty B. Holdings. We were unable to get a response from the Wayfarer parties despite multiple attempts to reach them. While we understand the court's position on the presumption of public access, which attaches to judicial documents submitted in support of the summary judgment motions, as this court has recently stated, the common law and First Amendment rights of access are not absolute. In particular, countervailing factors can overcome the presumption of access and warrant continued sealing or redaction of documents. A commonly found countervailing factor is the prospect that public disclosure of confidential business information would subject a party to financial harm. Okay. This court recently granted sealing of confidential business information and the personally identifiable information of third parties in documents submitted in connection with summary judgment motions. As to the Betty B. operating agreement, it contains information about the identity of the other members of Betty B. This court already held that the identity of unrelated non-party clients may be sealed. In addition, the agreement explains how Betty B has decided to structure and manage its business, which could provide valuable insights into a company's current business practices that a competitor would seek to exploit. Moreover, the agreement is cited just once in the Wayfarer party's summary judgment papers. And solely for the proposition that Lively's wholly owned entity is a member of Betty B. Holdings LLC. Given the extremely limited relevance, if any, of the operating agreement itself, as opposed to Ms. Lively's ownership, Betty B. requests that the agreement remain under seal. Okay. I mean, I think so far, I've obviously got a bit more to read, but so far this seems like a more rational and logical reason to request continued sealing than Isabella Ferrer's reasons. As to the competitive business information, the board updates, which I discussed extensively in the above referenced portions of the expert reports, are littered with sensitive competitive business information, including financial results, forecasts for future years, detailed competitive positioning of the brand's internal strategy, and plans for the future of the brands, the disclosure of any of which could harm the company. Just going to blow that up a bit. The board updates, each of which is labeled confidential on the cover, contain almost exclusively private, highly confidential company information and the expert reports. Rely extensively on information from those documents, as well as additional financial analysis and calculations based on Betty B's historical performance and forecasts. Likewise, the K1s contain certain financial results for 2 years and are relied on by the Wayfarer parties solely to show that Miss Lively receives distributions indirectly. The deposition transcript excerpts discuss sensitive competitive business information, specifically competitive brand positioning, and Betty B asks that just 2 pages of the transcript submitted remain sealed. Courts in this district have routinely protect from full disclosure exactly this type of sensitive competitive business information. I agree with that. Although Miss Lively indirectly owns a minority interest in Betty B is a third party to the dispute, making sealing even more appropriate here. Given the foregoing, Betty B asks that the court continue sealing the above referenced competitive business information as set forth supra on pages 1 to 2 and notes 2 to 6. Okay. I think that's a very well argued and well reasoned motion, to be honest. It's a business, and trade secrets is one of the kind of the categories that documents that end up, being sealed fall under. So I think this will be granted. Personally, I can't see a reason why it wouldn't be. But I actually agree with that in this case. There's nothing really of interest. Their use is very limited, but they're obviously, these come under trade secrets and, private privileged business information. Yeah, I think that's all I've got to say about that, actually.